Something big is coming down the pipeline in California, and it's not just about tech, and it's definitely not just for big companies. Hi entrepreneurs, I'm Vicky Brown, and you're in the right place if you want to engage your team, boost your business, and grow your leadership muscle. So starting October 1, 2025, California is flipping the script on how businesses use AI in the workplace. And if you've been thinking, we're just a small team and we're really not doing anything high tech, well, I need you to pause and take a closer look, because what's coming next affects how you hire, how you promote, how you evaluate, and most importantly, whether those systems are fair, legal, and defensible. First, let's be honest. AI is already in your business. You may not have planned for it. You may not even realize it's there. But if you're using an applicant tracking system that scores resumes, or software that flags the best candidates, or tools that auto-reject people who don't check a box or meet a keyword threshold, well, you're already in the world of automated decision-making. And California just made it clear. Those tools are now on the legal radar. Under the Fair Employment and Housing Act, the state has finalized regulations that apply to what they're calling automated decision systems, or ADS. That includes AI, algorithms, machine learning, and even rule-based filters. Anything that's helping you make a decision about someone's job, pay, promotion, or opportunity. And here's the part that matters most. Even if a human is still involved, if the system helps influence the decision, it counts. Now, before we go any further, and if you followed my content for a bit, you know what I'm about to say. I'm not a lawyer, and this most definitely is not legal advice. This is just a heads up about a new regulation. But you absolutely need to circle around with your employment attorney to get the fully vetted overview of what obligations you may or may not have and how to tackle them. So just think of this as food for thought. The keyword trap is where a lot of leaders get caught off guard, especially smaller businesses. So let's say you're doing a keyword search on a job board. If you or someone on your team is manually entering the search terms, reviewing the results, and making your own decisions without automation doing the work, you're probably fine. That's not what California's targeting here. But the second your system starts doing the filtering for you, auto-rejecting resumes, scoring applicants, hiding people who don't meet preset keyword rules, that's now regulated. Doesn't matter if you review the final list yourself. If the system shaped that list, it's playing a role in the employment decision. And under California's new rules, that's exactly what they're watching for. The risk isn't the tool, it's the blind spot. Now let me be clear, this isn't an anti-tech rant. AI isn't the enemy. These tools can save you time, increase consistency, and help you move faster, but only when you actually know what they're doing. What California is saying here is simple. If the tool plays a role in employment decisions, then you're responsible for the outcome, even if that tool is built by a third-party vendor, even if it's embedded in a platform you didn't customize, even if you didn't realize it was running in the background. If it helps you make a hiring or promotion call, you own it. And that means you need to know what it's doing, how it's making decisions, whether it's been tested for bias, and whether it could land you in hot water. Bias testing kind of isn't optional anymore. Now, technically, the new regulations don't require bias testing, but they do something much more subtle and more powerful. They tell courts and agencies to consider whether you've done it. In other words, if someone files a discrimination claim and you can't show that you've tested your systems for bias, that lack of action can and will be used against you. The absence of effort then becomes evidence. Now, on the other hand, if you have conducted testing and if you've taken action based on what you found, well, then that can help strengthen your defense. So no, it's not mandatory, but it is absolutely expected. And for small business owners, that means you need to start asking your vendors the right questions. What kind of testing have they done? How often? What were the results? What did they change? If they don't know or won't tell you, well, that's a problem. And don't forget the all-important record keeping. Yep, let's talk data, because the record keeping piece is just as important. Under the new rules, if you use an automated decision system, you're required to keep all associated data for 4 years. That includes the inputs, the results, the training data sets, the system outputs, everything tied to how the tool works and what decisions it influences. And again, this isn't limited to tools you built. If you're using software from another company that screens candidates, you're still responsible for preserving that data. Now, this is going to require better systems, better documentation, and stronger relationships with your vendors. Because if a claim comes up and you can't produce the records, then you're exposed. And guess what? Your vendors are now your risk partners. You see, the regulations also expanded the definition of agent, and that's a big deal. If a vendor is doing something on your behalf using AI, even indirectly, you may now be considered jointly liable under California law. So, if the resume screener they built ends up excluding people in a way that violates anti-discrimination laws, well, that's now your problem too. And it's not enough to assume your vendors are compliant. You need to confirm it. You need contracts that reflect it. And you need documentation to prove it. Because here's the hard truth. If you're using AI and someone gets unfairly screened out, no one's going to care that you didn't build the tool yourself. They're going to care about how you used it and whether you were thoughtful, intentional, and compliant. Oh, we're not done yet. There's another layer of compliance, the privacy piece. You see, the California Privacy Protection Agency is finalizing its own rules around automated decision-making technology under the California Consumer Privacy Act. So now, it's not just about fairness, it's also about transparency and control. If your system is making significant decisions about employment, including hiring, pay, and contractor opportunities, then you may need to tell people what the system is doing, give them the right to opt out, conduct a formal risk management, and respond to data access or deletion requests. That's a whole new layer of responsibility. And again, it doesn't matter if you're a 500-person operation or a 5-person shop. If you're eligible under the Privacy Act and using these tools, the law applies to you. So, what now? Well, here's what I want you to do. Not as a compliance move, but as a leadership move. First, map your tools. What software are you using that touches hiring, promotion, pay, or evaluation? Second, talk to your vendors. Don't assume they're compliant. Ask about bias testing, data retention, auditability, and get it in writing. Third, document your internal process. Who makes the final call? How is automation involved? Do you have a human check? Are you saving the right records? And finally, stay curious. The laws are changing, and they're changing fast. You need to stay flexible and informed because the decisions you make today could have consequences years from now. This isn't about being scared of technology. It's about being responsible with it. The smartest leaders won't avoid AI, but they will use it wisely. They'll stay ahead of compliance, they'll protect their people, they'll build systems that work, not just for speed, but for fairness. That's the bar now. And ready or not, it's here. And if you're wondering where to start, well, I've got something for you. I've put together a clear, step-by-step AI compliance checklist specifically for California employers. It walks you through what to look for, what to ask your vendors, and how to protect your business. Whether you're using AI tools today or just want to be prepared, this checklist is the easiest way to get grounded. You can download it using the link in the description below. And remember, your inspired leadership is the secret sauce to having a high-performance team and a wildly successful business you'll love. I'll see you next time on Leader's Journey.